Hi everyone. We might just give it a few seconds just as people filter through and then we will kick off. All right, so I see we're at just past 101. So we might get started. Good afternoon, everyone. My name is Sean Dunnigan. I'm chair of the Compliance Institute's Funds Working Group. And thank you for joining us today for today's webinar titled The Countdown to UCITS and AIFMD Regulatory Reform. The Funds Working Group are delighted to be partnering with Maples Group to provide Compliance Institute members with an overview of the changes to the AIFMD and UCITS regimes, which will take effect from the 16th of April 2026. While I'm sure that implementation plans are well advanced, if not nearing finalisation at this point, those impacted may find some late inspiration and clarity on what remains to be clarified from a regulatory perspective as of today. For those attending the webinar not directly impacted by AIFMD or UCITS reform, we hope you find this session educational. A couple of housekeeping items before we begin. The webinar will run for approximately 1 hour. As always, we encourage you to ask questions using the Q&A function. We'll address these at the dedicated Q&A segment at the end, and if there are any follow-up questions that we don't get to, we can follow up via email afterwards. The CPD code will be sent to attendees when the session concludes, and the recording will be uploaded to the library section of compliance.ie. Final point from me, the Funds Working Group will be delighted to hear from members who are interested in participating as a member of the Funds Working Group. So please feel free to reach out to the Compliance Institute should you wish to participate. I will now hand you over to Ian Conlon and Katrina Carty from the Funds and Investment Management team, as well as Philip Keegan, partner within the Financial Services Regulatory team, all from Maples. Thank you.
Thanks, Sean. First things first, I'd just like to say thank you very much for the opportunity to speak to the Compliance Institute today. We're delighted. So thank you personally, Sean and Fiona, in facilitating this. I know a lot of work and effort goes into organising these webinars. So, to all the attendees, we hope this will be a great and meaningful session. So for those who don't know me, my name is Ian Conlon. I'm a partner in the Funds and Investment Management Group in Maples, Ireland. I'm delighted to be joined today by two of my colleagues and two fellow partners in Katrina Carty and Philip Keegan, who will be walking you through this presentation. In terms of an agenda for today's session, we will give you a brief introduction of the Maples Group, but then we'll get into the meat and bones of today's session in terms of AIFMD2, the key changes, and drilling down into those key changes like the liquidity management tools, the enhancements to the delegation and oversight regime, the introduction of the loan origination regime as part of AIFMD2, and then we'll sort of finish up with sort of some of the key considerations ahead of the implementation date of the 16th of April. What people need to be thinking about as we sit here nearly just shy of 2 months from the implementation date. So just moving on to the next slide. So, in terms of like the Maples Group and who we are, well, we're a financial services group operating across 15 jurisdictions globally. We have a presence in all major fund domiciles, practicing the laws of the Cayman Islands, Ireland, Luxembourg, Jersey, and BVI. And in a European context, that having the operations in both Ireland and Luxembourg, the two largest fund domiciles gives us a unique vantage points and insights into how both the CSSF and the CBI approach regulatory change, such as AIFMD2 and compliance to that. In terms of Maples Ireland, we are a full service law firm. So in addition to the financial services capabilities, we also have sort of capabilities across the spectrum in terms of banking, corporate tax, taxation, property, all you would expect of a full service Irish law firm. We are celebrating our 20th anniversary in Ireland this year. We probably have a headcount now in excess of 550 people. So it's been quite a success story. But as I said, consistent with the speech today, was like our core areas of focus will be financial services and investment funds. So we're quite well placed to speak to the points on the agenda for today's session. I'm going to hand you over now to Philip, who's going to walk you through some of the key changes that have been introduced by AIFMD2. Philip?
Thank you, Ian, and good afternoon, everyone. Philip Keegan, a partner in the regulatory group in Maples. So I suppose the purpose of this slide is really just to kind of outline what we see as the key changes coming in under AIFMD2. We've also been doing a lot of work in preparation of the implementation deadline of 16th of April, as I'm sure many people on this call are as well. But I think kind of to take a step back, I think we would probably see AFMD 2.0 as probably more of a refinement or a tinkering of the existing framework. It's not necessarily a wholesale overhaul. And probably there's almost an exercise in itself to kind of pull out and extract what is a new obligation and what needs to be addressed by each fund management company and each fund as well. And I think also maybe a key part of this is also maybe trying to ascertain, look, what is a positive new obligation you need to comply with versus what is maybe a clarification or a codification of existing expectations. We're going to step through some of these topics in a bit more detail, but even just to kind of give a high level overview of each, I suppose, firstly, on delegation and operating models, there's going to be minimum substance requirements introduced for fund management companies. And there's also going to be changes to the scope of delegation and reporting requirements. Obviously, we would say that, look, most Irish fund management companies will likely be well set from a substance and operating model already, given CP86 and the central bank's regime. But we will cover the changes to delegation in a bit more detail later on. In terms of liquidity management, there's obviously going to be the introduction of harmonized liquidity management tools. We'll have enhanced obligations in terms of having policies and procedures in place around liquidity management. And I think as many people on the call will be aware, look, a key focus for industry, probably ahead of the 16th of April deadline, has been doing that gap analysis of existing fund documentation to try and ascertain, is it meeting the level one requirements? Do you have the required minimum liquidity management tools? And this is something that Katrina is probably going to speak to in a little bit more detail. Following on from that, then there's going to be changes as well relating to investor disclosures in terms of prospectus disclosures or pre-contractual documents. And one of the key ones we've just touched on there will be additional disclosures in relation to liquidity management tools for all UCITS and all open-ended AIFs. However, there will be additional ancillary changes to consider for documentation, including disclosure around costs and fees for AIFs, which are borne by the AIFM. One of the big changes coming in under AIFMD2 will obviously be the loan origination regime. So introduction of a European-wide loan origination regime, which is going to result in the removal of the Irish fund-specific LQAF regime. And again, Katrina will cover this in a little bit more detail. Then finally, just to note, there is going to be also enhanced regulatory reporting coming in under AIFMD2. This will include updates to kind of the Annex 4 type reporting, but as it's not coming into effect until 2027, we don't necessarily propose to cover this in any great detail today. We will look at maybe some of the changes coming in under delegate reporting, but I think we'll probably keep it quite high level for the purpose of today's run through and focus a little bit more maybe on liquidity management and delegation. So I think I'm going to hand over now to Katrina.
Perfect. Thanks, Philip. So, yeah, definitely one of our hot topics for today and probably for a lot of people on this call, liquidity management tools. So, as Philip said, AFMD2 introduces a harmonized LMT regime for open-ended funds, both UCITS and open-ended AIFs. From April 2026, less than 2 months away now, existing funds will need to come into compliance with the Level 1 directive, while the regulatory technical standards, the RTS, will apply from April 2027. The regulatory technical standards will apply for new products instantly, however. So what does that mean? So firms, AIFMs and UCITS management companies will need to select and implement at least 2 liquidity management tools from LMTs 2 to 8, showing on screen there with clear policies and procedures for their activation and their deactivation. It's worth noting that redemptions in kind are not eligible for retail product. So this work stream is broken into 2 main parts. Number 1, what's disclosed in the fund documents, and number 2, the operational policies and procedures that underpin liquidity management. If you haven't already, firms need to conduct a gap analysis of their current liquidity management frameworks. We're doing a lot of these at the moment. They need to map fund liquidity profiles and select appropriate tools. What that gap analysis entails is reviewing your constitutional documents, reviewing your prospectus, reviewing your supplements to determine on a per sub-fund basis if sufficient tools are available to the manager. Your policies are also going to need to be updated to reflect the selection and the calibration of the tools, and fund documents, as Philip has said, will need to be amended to disclose the conditions for their use. Operationally, you will need robust stress testing, scenario analysis, clear communication protocols for both investors and regulators. And I guess it's important to distinguish between the changes required at fund documentation level and also those required in the policies and procedures. Starting with the fund documents themselves, once you conduct that gap analysis, if you haven't done so already, start today. If insufficient numbers of LMTs or existing LMTs require updating for level 1 or level 2 compliance, fund documents will need to be updated to reflect the new disclosures following discussions with your portfolio management team, your investor relations team, and your fund product boards. Even though we do have a year for existing products, we would also consider amendments required for RTS compliance so that halfway through the year, you're not tinkering around with the tools that you have selected. Changing your mind from an investor relations perspective is generally the approach we've seen managers look to implement their tools, including those in compliance with RTS, generally speaking now. For AIFs, there's explicit Article 23 pre-contractual disclosures to be updated to add details of the possibility of and the conditions for using liquidity management tools selected in accordance with Article 16.2b of the directive, and that approach is broadly being reflected for UCITS. Firms will also need to factor in what investor interaction is required when amending your fund documents, need to factor in timings for approvals, implement changes, and any knock-on impacts on passporting where relevant. In terms of dealing with your delegates, dealing with your fund board governance, you should liaise with your investment managers, with your administrators on the operational aspects of any amended LMTs. Check the amended LMT measures are compatible with distribution arrangements, including third-party platform arrangements, and consider the interaction between the AIFM's LMT policy and the fund board's powers and obligations. In terms of central bank filings for fund document updates, the central bank have advised that a fast track will be available for UCITS, while AIFs can avail of their usual 24-hour filing process. For UCITS, the central bank has clarified that it will permit immaterial changes to be submitted alongside the fund document updates, more generally, which is positive. So at the same time as updating your fund documentation, internal policies and procedures will need to be enhanced to ensure the operational readiness and compliance with the new regime. Liquidity management systems and effective procedures will need to be put in place to take into account the investment strategy, the liquidity profile, and the redemption policy for each fund. You're also going to need to ensure that your staff are aware generally on any amended liquidity management policy. It's also worth noting that in the directive, AIFMD notes that the policies will need to be communicated to the regulator. That process is still to be determined. We don't have visibility on that. So in the background, we are working with fund mancos to ensure their policies are up to date regardless. We'd also flag any ongoing notifications required to home state competent authorities on the activation or the deactivation of LMTs. And on that, we'll take questions afterwards because I'm sure there are plenty. But I'll hand over to Philip on delegation for now.
Thanks very much, Katrina. Sorry, excuse me. Yeah, so if we could just, I suppose in terms of, the changes coming in under delegation, I definitely think we would see this being one of the most important points and a particular focus area. I think it's fair to say, look, the changes coming in under delegation aren't necessarily night and day changes, but there definitely are important positive new obligations, and we kind of think there's maybe a shift in the expectations around delegation. So fundamentally, mancos obviously remain fully responsible for delegation. You must avoid becoming a letterbox entity. But I think we would see AIFMD2 as kind of pushing managers to demonstrate more substance in their delegation framework and maybe a more granular level of AIFMD or UCITS level compliance throughout the delegation chain. So probably where we see this kind of first kind of coming into play will be in terms of the authorization of new fund management companies. So AIFMD2 is going to require that you provide more information on delegation. And I think it's fair to say that technically a lot of this information is only going to be required at the authorization stage. So at the authorization stage, a new applicant is going to have to provide granular information on their delegation framework. And I suppose some of the information you'll need to provide a regulator with will include maybe the legal name, the jurisdiction, the supervisory authority of any delegate. You'll need to provide a detailed description of the resources within the ManCo for performing day-to-day portfolio management tasks and also for monitoring any delegated activity in relation to portfolio management or risk management. You're going to need to be able to provide regulators with a description of delegated portfolio management and risk management functions, including whether this amounts to a partial or full delegation, and then also a description of the periodic due diligence measures that the ManCo will be carrying out for monitoring any of this delegated activity. So I think, look, although this information, or sorry, this obligation is technically limited to new applicants, we would very much see this as creating a de facto standard for all existing ManCos. So probably existing ManCos should probably be thinking about, do we need to do a gap analysis here and see, look, if this information was requested by an NCA, do we have that information available? The second change that we're probably going to talk about in a bit more detail, I might come back to in a few minutes, is reporting. There's going to be additional obligations in relation to ongoing reporting on delegation. But what I want to talk about, I think, for a minute or two here, and I think this is probably one of the key points when it comes to delegation, is there's now going to be an express requirement under the directives that all delegates and subdelegates comply with the directive itself. So previously, ManCos needed to ensure that delegated functions were being performed effectively and in compliance with applicable law and regulatory requirements. And I think it's probably fair to say that this left some ambiguity as to whether the delegate was required to comply with the specific provisions of the directive itself or merely with the laws and regulations applicable in its own jurisdiction. And we think that, look, this express reference in AIFMD2 requiring delegates to comply with the actual directive really does clarify that ManCos must ensure its delegates, and this is regardless of their location or regulatory status, that they are adhering to the substantive requirements of the directive. So I think one example we often come back to maybe would be in the context of portfolio management. If you have an investment manager doing best execution, this would probably need to be aligned with the AIFMD or UCITS requirements. So kind of to map through those kind of operational considerations. And we also think probably as a consequence, ManCos will start to need thinking about, look, have you ensured your delegates' policies and procedures and their conduct of business rules as they relate to the delegated functions? Are they aligned with the specific requirements of AIFMD or UCITS, as the case may be? And potentially, for any new delegation contracts being entered into, you might need to think about, do we need to kind of revisit our kind of template contractual terms to ensure you have specific provisions requiring compliance with AIFMD? I suppose then the next thing to kind of flag would be the scope of delegates. And again, I think there are some important changes coming in here and probably, some notable clarifications. So AIFMD2 does clarify that the scope of third parties subject to the delegation requirements will encompass any third party carrying out on behalf of the ManCo one or more of the Annex 1 functions under AIFMD or the Annex 2 functions under the UCITS directive, but also where the ManCo has MiFID top-up permissions and they delegate any of those kind of MiFID services, that will also fall within the delegation requirements. So really this clarification effectively ensures that any third party to whom a ManCo delegates any of these core or ancillary functions will be subject to the delegation requirements and the oversight obligations. An example of this might be, potentially whether the administrator is being classified as a delegate of the ManCo or not. So probably an exercise there for ManCos to go back and look, are we clear who is within our kind of delegation chain for the purposes of AIFMD2? And I think also the change being introduced as regards the MiFID services really does close any interpretive gaps that were there previously. It squarely brings into scope entities who are performing maybe those IPM services on a delegated basis on behalf of a ManCo. And I suppose kind of taking that through in terms of the next step, you'd be saying any of those delegations of any MiFID functions now technically would also trigger NCA notifications before they become effective. The other thing as well, just to flag, I think in terms of the scope of delegates, and probably something that has kind of piqued a lot of interest, is that clarification which has been introduced that I suppose with respect to distributors. So under AIFMD 2.0 now, where marketing with respect to a fund is being performed by a distributor that is acting on its own behalf and so is not at the initiative of the ManCo, and that marketing is being done under MiFID or through insurance-based investment products under the Insurance Directive, that marketing will technically not be considered delegation subject to the AIFMD or UCITS delegation requirements. And this actually is regardless of any distribution agreement between the ManCo and the distributor. So we might just skip on to the next slide there, Katrina, if that's okay. Thank you. So I think to try and kind of bring this all together, and all those kind of subtle changes that are coming through, we think there are probably, from a compliance perspective, maybe some important steps that could be taken or they kind of consider putting into effect as the deadline approaches and even kind of post day one compliance. Probably the first one I think would be taking a look at your existing delegation policies in your framework and maybe kicking the tires on it, saying, are we happy it aligns with AIFMD 2.0 expectations? This is definitely something we're working on with a number of clients. I think, you're probably looking at, what enhancements do you need to make to that policy? Does it kind of have a comprehensive delegate register? Do we have policies and procedures around how we document due diligence? Clear protocols around the KPIs we need? What's our internal escalation protocols? And I think if you're in a kind of an Irish ManCo, look, a lot of this is going to be familiar to you already. You'll have kind of had experience with the central bank's outsourcing guidance, but I suppose kind of the nuance here is we're moving almost from guidance now to law. So really probably worth having another look at those policies and procedures. The second point then would be, as I alluded to earlier, kind of for any new delegate contracts, I would say you're probably going to want to take a look at those again and see, look, are we happy they have the requisite provisions to ensure AIFMD 2.0 compliance? I think, at a high level, these contracts, they're probably going to need to include provisions which will have explicit undertakings that will require the delegate to perform the delegated functions in accordance with applicable AIFMD or UCITS requirements. Are there clauses in there which have, provide for detailed cooperation, information sharing, access clauses that really give a ManCo, clear provisions for, monitoring and ongoing audit of a delegate? Do you have clear KPIs mapped into either the agreement or any service level agreement that's kind of mapped back to AIFMD or UCITS requirements? Are there kind of defined thresholds or requirements around any sub-delegation, any your permissions and controls? So I suppose as a ManCo, you've clear visibility on any sub-delegation throughout the chain. And also that you have kind of clear escalation and termination rights in line with the expectations under AIFMD 2.0. The other thing I think maybe to kind of put on this kind of compliance kind of calendar for looking at these contracts as well will be, look, where contracts are being looked at for AIFMD 2.0 as well, it might be an opportune time as well, look to consider any ancillary legislative regimes to which the ManCo is responsible for, or to which is subject. So you might kind of book it in that category, SFTR, SFTR, EMIR. Are there clear provisions in the contracts covering all of these kind of additional regimes? And again, this is something we've been working on with a lot of clients to make sure all of that is kind of mapped end to end in those delegation contracts. Turning to kind of oversight and due diligence. Look, as we said, there are enhanced expectations around due diligence and oversight of delegations. So I think, probably from a compliance perspective, you'll need to be considering, do we need additional operational controls in place? Do we have a clear risk-based periodic due diligence calendar for delegates? Does this cover the initial onboarding, any ongoing monitoring? Do we have kind of event-driven reviews? Are we documenting the frequency and scope of this ongoing oversight? Do we have a clear and consistent methodology for kind of allocating time internally in terms of what staff time is being allocated to delegate oversight? Do we have a clear line of sight and kind of methodology in terms of how do we identify the amount of our assets which are being managed on a delegated basis? And then maybe kind of, in terms of the board interaction, are you happy the relevant ManCo board or, is getting kind of regular structured reporting on delegate performance? Are they being informed of incidents, remediations, and trends with delegates? And really, can your board minutes and your governance structure really evidence that kind of ongoing oversight, challenge, and follow-up that can really demonstrate I suppose have that effective delegate oversight model in place, all the way from the board down to the kind of designated person team. I think then to close out on probably delegation, and just kind of as I mentioned earlier, there are some changes coming in terms of regulatory reporting. So, and this will be particularly relevant in terms of the context of delegation. So from 2027, ManCos are going to provide ongoing reporting on delegation and sub-delegation arrangements concerning both portfolio management and risk management to national competent authorities. When these changes come into effect, I suppose some of the kind of headline points you're going to need to be reporting on will be the amount and percentage of assets which are under delegated portfolio management on a per fund basis, the number of full-time employees within the ManCo who are monitoring delegates, what is the due diligence timetable you have in place as the ManCo, and again, in terms of this due diligence which is being undertaken, what issues have been identified, what remediation plans have been put in place. So definitely something to think about going forward, that like come 2027, we'll have this additional reporting that we need to be making to national competent authorities. So I think, as we said, a lot of the focus has been on LMTs and that kind of gap analysis for day one, but we do think delegation is a key work stream as well. And I think a lot for people to be thinking about as we kind of head into 16th of April. I think Katrina is now just going to run us through some of the changes to loan origination. So I'll just hand back to Katrina now.
Thanks, Philip. So on to loan origination, and this will be relevant for certain of the managers in the room, those AIFMs which manage AIFs that engage in loan origination, and of course those fund boards of the relevant AIFs as well. So the EU Commission has sought to create a harmonised framework for loan originating activities across the European Union, with the aim of improving risk management across the financial market and increasing transparency for investors. There is a clear distinction between AIFs that originate loans and loan originating AIFs. For all AIFs that originate loans, regardless of thresholds or levels of NAV exposed to loan originations, certain core obligations are introduced by AIFMD2. Is again no de minimis thresholds, but additional requirements will apply to AIFs that meet the criteria to be classed as loan originating AIFs. So on that basis, the two key questions to consider to determine if an AIF is in scope for the purpose of the regime: number one, does the AIF participate in loan origination activities, in which case they are in scope for the core requirements? And number two, does the AIF meet the definition of loan originating AIFs and is therefore subject to additional requirements? So what is the definition of loan origination under the directive? It's the granting of a loan directly by an AIF as the original lender, or indirectly through a third party or an SPV. In terms of directly, there is no definition of that, but we can leverage from the existing central bank regime are you a day one lender of record? From the perspective of the CBI, there is an existing accepted distinction between originating loans and investing in existing loans which have been originated by another party. There's also an ACTI circumvention measure in Lim 2. The definition applies on a look-through basis, regardless of whether the origination is via an SPV, for example. If you meet this test of loan origination, you will be subject to the core requirements under AIFMD 2. By contrast, or in addition, the definition of loan originating AIFs is an AIF whose investment strategy is mainly to originate loans or whose originated loans have a notional value that represents at least 50% of its NAV. There is no definition of mainly. That can be assessed based on investment strategy and objectives of your AIF, and Lim 2, the 50% is a question of fact. So if an AIF is participating in loan originating activities, it is subject to certain core requirements introduced by AIFMD 2. What that means is that the AIFM will need to establish policies and procedures for the granting, administering, and monitoring of credit, policies that will need to be effective and proportionate, and they'll need to be reviewed annually. It's something that we're working on extensively at the moment, and many managers are leveraging off their existing policies and procedures for loan quaifs, and managers of funds not established in Ireland are leveraging off similar policies. It's probably worth noting that the prescriptive nature of the policies and procedures in the existing LQAIF regime is not there under AIFMD 2, but at the same time, that's something that we can certainly leverage off. You'll also be obligated to meet certain diversification requirements to avoid concentration risk for certain categories of borrowers. The fund will also need to adhere to restrictions on related party borrowers and the prohibition on originate to distribute strategies. There are loan retention requirements. Where an AIF transfers a loan that is originated, it needs to retain 5% of the notional value of the loan for a period of at least 8 years or to maturity date. So they are the core obligations that apply to all AIFs that originate loans, regardless of the threshold or the proportion of the portfolio engaged in loan origination. There are additional obligations that apply to loan originating AIFs. The main one that we would flag here, and the one that has the most impact, is in terms of leverage for closed-ended funds, which many of these funds will be. The leverage threshold is 300%. That's calculated on the existing commitment methodology under AIFMD. There is also some ability to cure inadvertent breaches, and subscription line financing and borrowing arrangements covered by capital commitments are excluded from leverage calculations. In terms of timing, there are grandfathering provisions in place. There's transitional period ending on the 15th of April 2029, which applies subject to quite a bit of nuance, but I'll walk you through where your funds might fall depending on when they were constituted and when they ceased raising capital. So for AIFs constituted before the 15th of April 2024 that do not raise additional capital after that date, there's nothing to see here, essentially. They'll be deemed to comply with the requirements on leverage, diversification and liquidity requirements, rather than needing to come into compliance by April 2029. For AIFs that are established prior to the 15th of April 2024, but continue to raise capital, they have until the 16th of April 2029 to comply with the relevant diversification and leverage limits, subject to certain exemptions. Then for new products, post-April 2024, they will need to comply with the provisions of AIFMD 2 from the 16th of April 2026. And finally, in terms of loans, where loans have been originated by AIFs before the 15th of April 2024, pre-existing loans, certain requirements won't apply to those actual loans, including the 5% risk retention requirements. It's worth noting also in terms of AIFM permissions, the Central Bank have recently stipulated that there is a new requirement for AIFMs to seek the additional loan originating permission under Annex 1 of the directive. This should be a straightforward process, but it is an additional hoop that AIFMs will need to jump through in terms of your timing considerations for compliance in April. It also means that you'll need to ensure that your loan origination policies and procedures are up to date. So I will pass you back now over to Ian to recap in terms of the key next steps that managers need to take prior to this coming April, and some key considerations going forward, as well as plenty of grey areas that are worth discussing. So over to you, Ian.
Apologies, I muted the mic, and Katrina, Philip, feel free to join in on this. So we just thought, as we said at the outset, we just finalise with some of the points that of concern over the next couple of weeks and ahead of the 16th of April deadline. Some which we've already covered, so I won't dwell on them. In terms of the Philip touched upon the sort of contractual delegation points. Should you look at your contract, your delegate appointments? Are they sufficiently covered? Equally, there is a little bit of a grey area developing in terms of delegation to fund administrators. The CSSF is sort of firmly take the view that they're outside of scope, where they're directly appointed by the fund. In Ireland, where the practice is sort of tripartite, and the AIFM is appointed the fund administrator directly. That then flows that it is a delegate of the AIFM. From a personal perspective, I think the latter is probably the correct view, because fund administration is a AIFM function under the directive. So there is that sort of line of delegation between the two entities. In terms of the CP 161 and 162 timings, I know this was a question was raised in advance of the session. Our understanding today is that the central bank will issue it next month. We don't have any certainty as to when, but it will be issued next month. We don't expect that there's going to be significant changes to the draft that was circulated pre-Christmas. That was always the understanding from an industry perspective, that it was going to be a sort of, it was open to consultation. It was going to be a refined process. The hope would be that what we saw is going to be very close to the finalized version of what will ultimately become the revised rule book. You are probably all aware of the sort of ongoing debate with regard to the impact of introducing or the LMTs on constitutional documents. I think it's fair to say that at this stage, the industry is taking a view that not to update the constitutional document at this juncture and wait for the RTS. I think this has more of an impact in the UCITS space than it would do in the alternative space, principally on the basis that I think the vast majority, certainly I'm speaking from an Irish fund context, there's broad stroke coverage in terms of the 9 LMTs that Katrina went through. What's clearly going to be an outlier in the UCITS space is the ability to side pocket. That's heretofore been an exceptional basis for UCITS. I think I've only ever seen it in recent years in terms of sort of sanctioned assets and Russian assets. So, introducing side pockets and by virtue of updating constitutional documents where you might have to seek shareholder approval is not an easy fix this side of April the 16th. So I think how industry is approaching it is that they are looking to rely on the other 8 LMTs, and suspension being a sort of a common liquidity management tool that all Irish and European funds would have access to. So whilst it's not an exact compliance or adherence, but they can point to sort of broad stroke compliance with the issues. Philip, I might maybe let you come in on the liquidity management policy update, so that's more at the managerial level as to what you're seeing.
Yeah, I think, kind of the waters are a little bit muddied, I think, for a lot of people with the kind of the transitional period under the level 2, whereby existing funds have I suppose until April 27 to kind of comply with the level 2 measures and also the level 3 guidelines. But equally, under level 1, there are requirements that I suppose managers have in place, policy for the selection, calibration, implementation of liquidity management policy. So we do think that it is something that certainly fund managers are going to need to give consideration to. I saw a Q&A come through there in the chat as to whether we know what's going to be the central bank requirements as regards filing that liquidity management policy with the CBI. I don't think that has yet been clarified, so it still remains to be seen. But I mean, given that there is that expectation under level one that that policy is in place and could be an obligation to submit to regulators, we do think that is something that managers should be giving consideration to ahead of 16th of April if they haven't done so already. So I think definitely kind of as regards liquidity management, to keep that kind of on the kind of the worksheet alongside the review of the fund documentation as well. Are we kind of getting those policies and procedures in place, albeit recognizing that there is a little bit of latitude maybe with some of the granularity in level 2 and level 3.
Do you want to maybe take an extension of that point, the delegation policy update, similar vein?
Yeah, no, similar vein. I think, with the delegation policy, I think that's probably a little more clear cut in that I think, most Irish fund management companies should have a robust delegation policy or outsourcing policy in place, given the outsourcing guidance, which we've all been familiar with for the last couple of years. So I think, again, as I said, look, a lot of these requirements kind of bite with the authorization of a new fund management company, but there is going to be, I suppose, new reporting requirements coming in 2027. We do think that probably a prudent approach is to look at a newly authorized manco, what they would have to provide the bank. So look, we probably need to gap analysis our existing procedures, policies, etc., and be satisfied that we could provide this to a regulator if required. And I think alongside the liquidity management policy update, we're also spending a lot of time with managers and kind of going back through those delegation policies. As I said, if a management company has kind of done their groundwork already on the outsourcing guidance, it's probably not going to be a fundamental overhaul, but definitely something that is worth looking at, I think, ahead of the April implementation date. I actually think there was a couple of other questions I saw come through on the chat relation to the delegation as well. So I might try and cover some of those off as well while we're here. As to whether a depository would be considered a delegate under the delegation requirements, no, we would say they still stay outside the delegation framework. They're not a delegate of the ManCo. In terms of distributors being how they're treated if they're not MiFID or through insurance-based products, are they considered to be delegates? I suppose, yes. Fundamentally, I suppose the starting point would be that they would be, a delegate if they're kind of being appointed by the ManCo to distribute the funds. So I think that would be probably the starting point. But I think, look, every fact pattern would have its own nuances. But look, if that is a very narrow carve out under the directive, so I think it would need to be looked at on a case by case basis.
Yeah, I'd agree with that. In terms of, I suppose, a distributor, marketing is an AIFM function. So if an AIFM appoints a delegate to provide one of its functions, it is per se delegate. So a distributor in that instance is a delegate, and the sort of Article 20 would apply. What AIFMD 2 is seeking to sort of carve out or recognise is that MiFID authorized distributors are already highly regulated, and adding the additional layer from AIFMD is unnecessary. So I think it was a pragmatic step taken by the European Parliament to recognise that and free up the hand of both the supervising AIFM and those MiFID authorized delegates. But those who are not CUP or those who are not authorized by MiFID, well, then Article 20 would still apply. There's other questions here in terms of third-party AIFMs managing loan origination AIFs. Would they be required to have their own policy procedures, credit policies, or rely on delegate IMs, and so on and so forth? I think the answer is yes, they would. But there's, like with anything in the third-party space, the legislation doesn't contemplate necessarily for the third-party concept. So you have to sort of shape your framework around that. But what is always recognised through various sort of CBI, thematic reviews, or Dear CEO letters, is that there's an expectation if you're delegating something that you have the capabilities to do it in the first instance. So whilst you'll have to have a procedural and policy framework at the third party manco level, which can also then place degree of reliance on sort of the appointed sub investment managers in the sort of who are operating the more day-to-day policies, but it wouldn't be the case that you have nothing and you just point to a delegate that would not be in line with the expectations of the directive.
Lots of policy questions. I think there was another one in terms of the liquidity management policy and the obligation to submit that to the central bank. It is hardwired into the directive that liquidity management policies will need to be communicated to the central bank, but there has been no communication to industry on what that would look like. So I think, the messaging on our side is make sure that you have your liquidity management policies up to date and in compliance with the directive, but we don't have visibility in terms of the nature of any CBI or other regulatory or national competent authority submission.
And there's another question, Philip, might give it to you because I think it's more better. Please clarify the dates for compliance. Do existing funds need to comply with April 26, or is everything not out till April 27? So I'm assuming that's the LMTs and the RTS. You want to maybe just touch on that?
Yeah, I think we're probably seeing kind of diverging practices taken by different managers. I think, look, fundamentally, the level 1 LMT requirements come into play for all funds in April 26. So I think every manager is going to have to do a gap analysis. And I suppose I'm probably more talking in the UCITS context here, given there's separate disclosure requirements in the AIF, but in the UCITS context, you will have to look at your fund documentation and try to establish, look, is there sufficient disclosure that we have the required minimum amount of LMTs? Is it clear when they can be kind of activated? And then it becomes kind of, I would say, a risk-based call for each manager in conjunction with their legal advisor. Are we happy that, look, for level 1 compliance, we have sufficient disclosures in our documentation? And as regards maybe some of the more granular disclosures or kind of calculation mechanics that come in under level 2, yes, we can potentially defer some of that down the road. So yes, we have seen managers get to the point where they say, look, as regards day 1, we're only looking at level 1, and we are happy that our documentation contains sufficient disclosure to materially meet the level 1 obligations, and we're going to kind of look at our level 2 updates over the course of the next 12 months. But I think the precursor to that is obviously that you have to do that initial gap analysis.
Yeah. And then I know, Philip, that's in terms of UCITS. For AIFs, the level 1 directive does stipulate for Article 23 disclosures for AIFs that your pre-contractual documents will need to be updated to add details on the possibility of, the conditions for, and using liquidity management tools selected in accordance with Article 16 of the directive. So it's quite explicit that pre-contractual disclosures need to be included on that for April 2026 for AIFs.
There's also another question just between the sort of the CBI's view on delegation and outsourcing. I would sort of answer that by it's very much we've done this analysis before for other clients, but fundamentally when you look at sort of this from a context of AIFMD, you've the outsourcing guidance state quite clearly they supplement AIFMD. So in the first instance, you have it if it is delegation under Article 20 of an AIFM function, well then you have to adhere to obviously the obligations of AIFMD. Then you need to consider sort of the outsourcing guidelines, which, as I said, supplement that process. And in that, as part of that analysis, you need to deem what you are doing as a critical and a critically important or non-important outsourcing arrangement. So it's all done on sort of the basis of a back pattern or analysis of the relevant sort of function or service that you're choosing to delegate. Like it's quite a nuanced point that you can't really get into here, but if anyone wants to follow up, I'm happy to discuss it because we have done that critical analysis for other clients.
We've had someone go a little bit off-piste in the Q&A that were submitted prior to the webinar, but we'll go there. What will be the impact on the Eligible Assets Directive for UCITS? So a cheeky question in there. I think on our side, it's just too soon to tell. ESMA's proposals that may have caused some managers some concern, they're non-binding. They form part of the Commission's wider considerations on whether to what extent to amend the UCITS directive. It is expected that the Commission will launch its own consultation where industry can submit views, and I think industry has been very strong in response to some of ESMA's proposals with a strong emphasis on the UCITS brand. So there's nothing to see here for the moment. We're certainly quite some time out from any kind of prescriptive requirements from the Eligible Assets Directive.
I think we've covered then all the questions. So we've got, nearly just shy of 10 minutes left. Is there any other questions from the floor? We're happy to take them. Or if not, we can hand back over to Sean to close out.
I think Ian, we have one final pre-submitted question as well, but you might have already covered this in some of the updates you went through. Are there any situations where UCITS may not have to change anything regarding its liquidity management framework?
Yes, I suppose that would be that would have been the point I just covered there. Look, in theory, yes, that could arise, but it kind of it's the precursor that look, you will need to do a gap analysis to see, look, does your documentation materially hit the level one requirements? It's going to be kind of almost a case by case assessment by each manager, but we are seeing some managers get to that point where they're comfortable our documentation materially meets level one requirements, so we're going to defer any prospectus updates for the time being.
Okay. I suppose at this point, obviously, if there are additional questions that come through, feel free to send them through, and we can reach out to the Maples team and respond accordingly. But I suppose not hearing any further or not seeing any further questions during this webinar, I would just like to say thanks very much to Ian, Katrina, and Philip for their time. It was extremely insightful, and hopefully members found it insightful as well. And like I said at the outset, we'll give you some inspiration or areas to focus on as we approach the April 2026 effective date. But unless there's anything else, I think we can draw the session to a close.
That's great. Thanks, Sean, again.
Thank you.
Thanks.
Thanks all.
Thanks very much.
Thanks
Hope
all.
everyone's okay.
Bye-bye.
Cheers.